Start. Learned counsel for the appellant, Miss Meena Kumari Das, the amicus curiae, who assisted the court in the matter strenuously, argued and submitted that the learned trial court, having found the evidence insufficient to bring home the charge under section 376/511 IPC, could not have convicted the appellant on the self same evidence. It is further submitted by the learned amicus curiae that there is no evidence whatsoever brought from the side of the prosecution with regard to the act alleged that could suggest that the appellant, being aware of the fact that the victim belonged to scheduled caste community, exploited her sexually. She also drew the attention of this court to the relevant provision of the Atrocities Act and further reiterated that the prosecution did not bring any evidence to attract the provision, either oral or documentary, so as to conclude that because of the fact that the victim girl belonging to the community of scheduled caste was exploited by the appellant. Learned counsel for the state, on the contrary, supported the impugned judgment and submitted that the version of the victim being consistent so as to derive that she was sexually exploited by the appellant because of the fact that she belonged to the scheduled caste community, and the conclusion derived by the learned court below being in conformity with law requires no interference. On a close scrutiny of the evidence laid by the prosecution through the victim girl, coupled with the evidence of PW 2, 3 and 5 and that of the medical evidence through PW 1, the very fact that the incident occurred wherein the victim girl was subjected to sexual exploitation cannot be denied, though not held proved on the charge under section 376/511 IPC. However, a pertinent question that strikes the mind of this court is that if the trial court held the evidence of the victim that fairly subscribes to the offence under section 354 IPC, what prompted the court not to hold the appellant guilty thereof? On this score, since the trial court took the view that the appellant is also charged alternatively under section 3 (1) 12 of the SC and ST (PA) Act, the conviction in the said offence would amount to double jeopardy. The state did not dispute this finding. This court, therefore, having not indulged itself in the arena of the subject matter, if it could be one coming within the ambit of the double jeopardy.